litigation is how you are able to gain respect for that intellectual property, which then allows you to get the relationships you want to establish. So, so what I'll do in this format, I want to talk for about another 15 minutes before we do questions and answers and have some discussion. But I'm going to do a quick overview looking at patent strategy from a chess framework. So I don't know, and I can't see a show of hands in this format, but I imagine if you don't play chess, most of you probably know the rules. And whenever you're conducting a chess strategy, you're looking at the material that's on the board, the pieces that are on the board, the space that's on the board, elements of time, and what is the relative risk. And so those are common frameworks that somebody playing chess or any other strategy game like this will look at. But it works very well for patents. So when you're looking at the material in patents, what are patents comprised of? They're claims on inventions. In the American system, what is considered patentable is a novel, useful, and non-obvious process, basically how something works, or a machine. You know, think about a car, or think about you know, any device that may have a process inherent with it. Often with patents, you'll claim both a machine and process as a part of the same thing. Manufacture, which is, for example, if you came up with a new shovel, something that's constructed or put together from innovation. And compositions of matter, this is where you start to get into the chemistry. Non-patentable ideas are non-patentable items are abstract ideas, laws of nature, and natural phenomena. So to particularly speak to the first one, because that's where we most often find that people run into problems. And some of you who were on the last call may have heard this example, but we have in the United States, you cannot patent software. It's difficult to patent across the globe, actually. But there are ways that you can successfully patent software if you are able to tie it to processes or machines, for example. And I look at it this way as an example. If you had a software that you wanted to patent that runs on a computer, you'd be unlikely to be able to patent that. If you had a software that helped to make the computer run better, and therefore we're tying it to the system that is the computer, then we may have some avenues to work with. So, but this was something that I worked with a lot at Walmart, since Walmart, when you really get to the core, is a data and logistics company of enormous size. Something that was spoken to on the last session, I also see this as well, that when you're inventing, a lot of inventors that I work with that spend a lot of time in very focused on their technology will fall into what I call the Mousetrap Fallacy. The Mousetrap Fallacy comes from a poem where the idea is that if you build a better mousetrap, people will come running to knock down your door for it. It was spoken more eloquently in the poem. That is rarely true. Inventions have to be sold. Most inventions will go through a phase similar to the phase as happened with the automobile. The first automobiles that were introduced were bought by people who just wanted the new thing. At some point, as the technology evolved, the automobile became something that people needed. And then it became where the want became more of a desire for different types of cars. So this is very similar to what was talked about in human-centered design. But you'll see the same pattern happen, for example, with the cell phones and then the smartphones. So whenever working on an invention, you always want to pay attention to what is it that somebody is going to buy. I did a lot of work, and Nadia was a part of this with me, at Hewlett Packard, asking inventors there, in a sense, what are the saleable aspects? What are the things that are going to excite people to make them want to buy it? Um, Space and time. I think Nadia will discuss some of these even further than I will, but some of what you're looking for in the Russian system, there is some similarity with the US system. Your utility patent is very much equivalent to what we call a non-provisional. We also will call it a utility patent, where you are looking for a term of about, looking for a term of 20 years after filing. In the United States, we have something that's called a provisional application, which can be very useful for entrepreneurs. A provisional application allows you to file a patent application um, ahead of filing your non-provisional. It's an application that in a sense serves as a placeholder. It allows you to get a filing date, which is important because around the globe we are on a first to file system. It allows you to do that first filing economically. A single provisional patent application can cover many inventions, so ultimately those would be broken out into individual utility filings. Um, but it, but then it, so it allows you to economically get that filing, have patent pending, so you're able to talk to potential investors, protected, and being able to say you have patent pending, a designation on your particular inventions. And then within that year, you've got an opportunity to do further development and decide whether it makes sense to invest further in that invention or to steer in a different direction. Okay. Another thing, the U.S. is very popular for not only because of its market, but also because it can be very difficult sometimes to patent in other areas. So I'll skip ahead for 1 second here, but as you're looking at importance of markets with the size, you're also looking for supply chain and enforceability. So for example, you can strategically gain some protections from Asia by having a US patent, because the US patent would prevent, would give you the right to enforce not having infringing material imported into the United States. So there is some global protection you're able to obtain even by selectively choosing a few countries. If you look at Walmart, when I worked there, and if you look at our published applications, it was very common, and you can see the pattern easily.
Hi
There,
guys.
of course, would be the US patent,
Oh,
a US based company.
oh,
We would get Canada, large market locally. We would often file
already.
in Great Britain,
What's it?
um, and then other
Hi.
countries, whether it was China,
Uh,
excuse me,
well,
or in some cases,
I
Russia
have
with some
seen
specific technologies in the drone space, for example,
the
it would be very regionally specific based on what that
webinar.
technology is. But
Uh,
we're able to get a lot of protection just
I
by
didn't
having even
participate
the US,
in this
Canada
webinar,
alone gave us
and
significant global protections
simultaneously,
based on how the company was
I
set up.
just
The PCT is another
put all
placeholder document.
information
This
on
is a
the
global patent.
presentation
It's filed
uh, to
through the World Intellectual Property
easier
Organization in
understand
Switzerland.
after
It allows you to
after this
designate
webinar. I can
152
check any
countries that you might
links,
want to file a
any
patent in. Again,
technical
it's very
information.
cost effective because that, kind of like the
So
PCT in the
again,
US, um, it gives you 30 months to decide whether to make further
so
investment
how
in
process
filing in a
of
given
effective
country. And
self-education
then all of that will depend upon the
we just
importance of the market in that
copy
country,
uh,
the supply chain that you're
all
trying to set up
slides,
so that you have some protections
uh,
throughout the supply chain,
Google
the enforceability.
uh,
Patents tend to be more enforceable in the US than
Google
many other areas in the world. And
presentations.
and you do want to pay attention to that when designing and defining your strategy. You also want to look, and it's not on this slide, but look at where your competitors are. If you've got a key competitor in another country, you may want to consider, pending advice from your legal counsel, filing patents in that country, that other country as well. Risks when navigating the patent landscape. There are many. So here are a few of them. I've already mentioned litigation, and so I'll actually go from the right to the left, therefore. But litigation is always a concern, and so ways to avoid that, among other things, is a solid understanding of your industry and doing the search and the research. And I tell my clients that if we find prior art, Nadia does this as well. If we find prior art that's a potential problem, there are ways to address it. It may be how we write claims. It may be suggesting different technology design around solutions, but it becomes easier for us to address it earlier rather than later. And so it's good to know what's going on in the industry. Innovation is the other risk you'll always face. I mean, you're patenting an invention, but other inventors, of course, are working on other solutions, and those solutions may in some way be better, faster, less expensive, or better positioned, than your own. So, the adage is those who have the best, the fastest, and least expensive aren't necessarily the winner in the market if there is an entity that is better positioned, has better relationships, and this will always be a challenge in the United States for companies that are coming from abroad, from outside the United States. Spare a few well-known brands. It can be more challenging simply because you are overseas. All right. There are validity challenges. If you have a patented invention that turns out to be very useful to somebody else, somebody who would like to use your invention, but for having the patent, one thing we might be looking for ideally is that might be an opportunity to license or to block that competitor, but that competitor may try to challenge that patent, excuse me, either in court or through a process that is loosely called PTAB, which is Patent, Trademark, and Advisory Board, which is in a sense, another form of court whereby people can challenge, a particular invention. And I have court and outside court. So the outside court will be where you are working with another entity to try to settle outside of court, and that might be what leads you to getting a license, for example. Infringement. So there are within the United States the difference between accidental and deliberate. The damages, you may hear the term treble damages, happens when you deliberately infringe. Somebody has something and that your invention works on, and you infringe it anyway. But again, this is one of the reasons that if you're working with counsel in the United States and you do find something, bring it to the attention early, because there often will be other ways to address the problem. And then there will always be prior art. It takes 18 months for a patent invention to become part of the public domain where you can search it and look for it at a patent office. And so there's always a possibility that in that 18 months from when you file a patent application, something will come up that you could not have seen simply because it was not available in the art. That's a risk all entrepreneurs take. Not much you can do about it except be aware of what's happening in your industry that gives you some idea of the likelihood. Um, I've talked about license. I want to get us to Q&A. So I want to wrap up this part of the discussion. Um, to conclude on this, when inventing and looking at inventing and patents, you can be very systematic in how you do it. And the pattern that you'll want to follow is to look first, what is the market advantage that you hope that your business, your technology will allow you to achieve? Break that down into what the user benefits are. 3 common ones are better, faster, less expensive. Take and maybe parse those out. What is better defined as? Does it last longer? Does it, does it in some way look better? Is it more durable? Start to spell those out. Then build your technology strategies around those user benefits, because that will take you towards avoiding the mousetrap fallacy and really defining that technology in the sense of what is it that somebody will be excited about and will be willing to buy. From there, you can pull that into different inventive principles and the universal universe of inventive principles. One of the ones, and some of you have seen this before, but one of the things that I recommend, and this is from Russia, and it helped me a lot. I have 156 of my own filed inventions, but this is a theory of inventive problem solving, where you've got 40 principles set up. And Heinrich Altschuler, who put this together, had said that if you really broke down inventions, all inventions solve one or a combination of 39 problems, one or a combination of 40 ways. Thinking that way, you can be very systematic about your innovative efforts and also ensure that you don't miss anything. So with that, I'd like to, here's our contact information. I'll leave that up for a little bit, but we can move from here to, well, first off, Nadia, I'm sorry I just talked straight through. Do you have anything that you'd like to add before we get to Q&A?
Добрый день всем. Мы сотрудничаем с Робертом уже 15 лет по разным проектам. Где-то лидировали это проекты, предложенные Робертом, где мы участвовали, где-то это наши проекты, в которых Роберт участвует. И это плодотворное сотрудничество давно продолжается.